Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments so that I may answer your questions. And I said before that I am staying with the theme of regarding VAWA this week. This whole week I'll be talking about it because there are a number of ways to apply for relief if you're being mistreated by a certain U.S. citizen or legal permanent resident in the United States. And so I want to talk about yesterday. I talked about the if you're the ex-spouse, right? You are the ex-spouse of a U.S. citizen or legal permanent resident, and that ex-spouse mistreated you. Mistreatment, it covers all different types of abuses and extreme cruelty, and that will include verbal, emotional, mental, financial. If they are extremely cruel to you, they do vindictive things against you, they're intentionally hurtful, they embarrass you in public, they're manipulative, they're jealous, they alienate you from your relatives. These are examples of behaviors that, if used against you, could qualify you for relief to apply for your own employment authorization and green card while you stay in the United States. It doesn't matter that you've come into the country without status. It doesn't matter that you may have overstayed. This protects you. And even if you say you've had an arrest in the past, or you've even been arrested in a domestic violence situation that involved this abusive spouse, there are ways to apply for waivers or to present the application in a way that they'll understand that what happened to you should be forgiven. So that's the first thing. But we often hear about VAWA only applying to the spousal relationship. Sometimes you'll even hear it's not even for men. And I'm here to tell you that it doesn't just apply to the spousal relationship. It doesn't even only apply to women. This relief is available to all genders and different types of marriages, including safe-sex marriage. So that's the first thing. Men can apply for this, and individuals in a same-sex marriage can apply for this. Now, what if you're not in a spousal relationship? What if you are in a different type of relationship? And when I say relationship, I mean parent-child relationship, that your parent is mistreating you or subjecting you to extreme cruelty, or even your child, your U.S. citizen child. Can you apply for relief under these circumstances? And the answer is yes. This is available for you if you are the parent of a U.S. citizen, and say that U.S. citizen child is now 21 or over, but this abuse has been happening from they were 18, or it happened when they were under 18. This could still qualify you, because even though as parents we don't want to ever think about our children harming us or our children being vindictive towards us, unfortunately these things happen. Your child, this may be a U.S. citizen child, they may have started out with emotional issues, they may have substance abuse issues, they may have lashed out at you in ways that became abusive or extremely cruel towards you, and you may be here without status. You may feel stuck. And as a result of that, your child has never applied for you, or even if they're applying for you, they're holding it over your head. This could qualify you to apply on your own. Now, I know one thing when it comes down to the parent, we are very protective of our children. And we don't ever want to, go ahead and file papers against our children saying that they're mistreating us. But think about it this way. First of all, this process is not there to hurt your child. It's there to provide you the relief you'll need to move forward in your process, to move forward with your life. And in some cases, to parent better, to be a better parent, to be able to gain all the access, have access to the resources in the United States that you need to parent your child or to help your child. Because at the point that you're applying for this, your child is going to be an adult, they're going to be 21 or over, but that we don't stop being parents, right? And so if you're in that situation where you need status, you want to move forward with your life and you want to be in a better position to help your child. Yes, they are going to be 21 or over, but nevertheless, they're our children. And if you want to be in a better position, this form of relief could be for you. Is it going to set the law enforcement on your children if you have to state and present evidence showing that they have mistreated you or subjected you to extreme cruelty? No, this will not cause law enforcement to burst through the door and take your son or your daughter away. This is for you to be able to get the relief you need to move forward. It's very confidential, and so it is not shared information that you're presenting to the Immigration Service about your U.S. citizen child, their emotional issues, maybe their substance abuse issues, maybe their abusive tendencies or their tendencies to lash out at you emotionally will not be disclosed to outside agencies. This is information that immigration officers look over. Now, I know the next thing you're saying is, well, how can I show emotional abuse or that my child lashed out at me? Well, it is important to know that the evidence here includes any credible evidence. And we, of course, do the heavy lifting. We help our clients to get to the point where they can prepare a good application to show these elements and these requirements. So you should not worry about that. But this kind of evidence you can present is very flexible in that you can present any credible evidence, because the Immigration Service understands that when you're being emotionally abused, it could be right up there with physical abuse, except there's hardly any evidence of it, right? While being physically harmed, you're going to have external scars. Sometimes you may have a police report, you may have medical records showing your injuries. When it comes on to emotional abuse, it is really internal scarring. And so they understand that there is a lack of evidence or a lack of fireproof evidence. And so what they have done is set the standard where if you can present evidence that will allow the officer to conclude that it's credible, your information is dependable information and consistent information, they will then find that you qualify for this relief. It's confidential. No one but yourself and me as attorney and the Immigration Service will know that you're applying for this. Nobody is going to contact your child. Nobody is going to contact anyone related to your child to ask them to give information or to sign anything. And as I said before, the goal of this isn't to send it to law enforcement or any other agencies to then investigate your child. It is there for you to be open and honest and to give the information you need to get that relief. So yes, you can get relief if you're out of status, if you came into the country without permission, if you overstayed your visa, if you're here with status, and you then need to move on to permanent residence, get your employment authorization, then these are possible through this process. If your child is mistreating you, or they're not involved, or they're not refusing to apply for you, or they're threatening to get you deported, these are ways that you can do it yourself and empower yourself. So I just talked about the parent, so that the parent applying for relief, but the child can also apply for relief. And I'm going to tell you how. So children, if you're under 21 and you're unmarried, you can apply for relief based on the extreme cruelty or mistreatment by a U.S. citizen or legal permanent resident parent. So this covers, while the parent-child relationship, a parent can only apply for it on the basis that a U.S. citizen, son or daughter who's 21 and up, is mistreating them. When it comes on to the child applying for relief, they have to be under 21, and the parent has to be either a U.S. citizen or a permanent resident. So the parent can be a green card holder. Now, if, say, you're over 21, can you still apply for this because you've looked back and you do remember that your parent mistreated you or abused you? If they beat you, if they put you down, if they called you names, if they embarrassed you, if they were manipulative, if they forced you to work. These are all examples, not an exclusive list. These are examples of forms of mistreatment that can qualify you. Even willful neglect by a parent can qualify you for this form of relief. Now, if you're over 21, you're 21 or over, this relief still may be available to you as long as you're under 25. And we will talk more. I usually talk with my clients about why they didn't apply before they turn 21. And then we can present the evidence if the evidence shows that the mistreatment was connected to the delay, then this could still be available to you, even if you're now 21 or over, but you're still under 25. So that's important to know. So if you are in a situation like that, where you're being mistreated by a U.S. citizen or legal permanent resident parent, or you're the parent and you're being mistreated emotionally, financially, physically even. Physical is not required, but physical is also qualifies you for this. If any of these apply, then you could apply for relief for your own status, your own work authorization, and your own green card, and stay here in the United States to do all of that without involving that child in your process. So keep that in mind. It's not just for women. It's if you're the father, it applies to you. If you're if you are in a situation where you're the mother, it applies to you. If you're the child, it applies to you. If you're under 21, but you can still be under 25 and possibly still apply for this. So if you're over 21 or over, the clock is ticking and you need to get to applying right away. Now, all right, let's see. Let's go ahead, and I'm going to go through your questions because I'm also here to answer your U.S. immigration related questions. So go ahead and put your questions in the comments and then I will answer. Can you please tell me how long will it take when your U.S. citizen married you? How long? So it depends on where you are. But if you're in the United States, I have had cases approved in as little as 5.5 months. However, it could go as long as 18 months. It just depends on how well your application is done and whether there are delays, whether there are RFEs. It also depends on if you're outside of the country. Right now, embassies are backed up all over the world. So we're seeing processing times going over a year for the process if you're outside of the U.S. How long does it take the appeal I-290B in Vermont? So it could take a while. It could take a couple months to up to a year to get that decision. Can you please tell me how long will it take when, all right, let's keep going. My mom work authorization got approved 2 months ago, but haven't heard back from her green card yet. So the work authorization gives one the ability to work and wait out the process. It may be the processing times. So it just depends on the case and the processing times to process the case. If I want to be a resident of the United States, how do I go about doing that? So there are different ways that you could qualify. You could qualify through a family member. The family member has to be either a spouse, a U.S. citizen or resident spouse, a parent. If you're under 21, then you could be the immediate under 21 and unmarried. Then you're the immediate relative. So you're the son or daughter of a U.S. citizen or legal permanent resident. That process is moving along faster. Permanent residents and U.S. citizens can also file for their children who are 21 or over. It's taking about 5 to 7 years for that if they're unmarried. And then siblings can apply, and U.S. citizens siblings who are 21 and over could apply for their sibling. And then U.S. citizen parents can apply for their married children, but that takes 12 years. Sibling petitions take a minimum of 14 years right now. Hello, does the USCIS require interview when applying the I-130? So the I-130, if you're filing the I-130 petition only, those interviews are rare. In some cases, they may ask you to come in for an interview, but those are rare. What they'll usually do is, if you've just filed the I-130 petition, they'll process the petition and then send it to the National Visa Center. How soon after you get your green card can you file for your children living in another country? Right away. There's nothing that says you can't file for your children. As soon as you become a green card holder, you can get it. I need help to apply for the I-751. Go ahead and you can go ahead and give us a call. We definitely do that for our clients. So you can go to the link in the profile. The first thing we do is start with a consultation to make sure that everything is good with your case and we can take your case. We also advise you, give you good information to make good decisions moving forward. And then we get straight to work once you hire us. All right. Great questions. Keep those questions coming. Okay, so I've been waiting for 9 months now for adjustment of status. It's marriage-based. How long? So I've seen them ranging anywhere from 5.5 months to it could be as long as 18 months. It just depends on how good your petition is and what's going on the back end. What's the processing time of the service center? I watch you all the time. I used VAWA. Oh, good. Congratulations. How long does it take the appeal? So I answered that. Okay, I am from Guyana. So Shakira. Okay, so greetings. Good afternoon. If my mom is a USA citizen but has never paid taxes, can she still file for her child? So when you're filing for the affidavit of support, you do have to file your taxes. And so that could be a potential issue. But my question to you is, why didn't she? Did she intentionally not file her taxes? Or is it that she didn't have to file? Because sometimes under tax law, you don't have to file your taxes. It's, you maybe your mom made very little each year, and because of that, she didn't have to file those taxes. So that's where it's going to be very important to get that follow-up information. But to get personalized legal advice, that's where you'll need to schedule that consultation. Misunderstanding 42, thanks for sharing the live. Hi there, Katie. It's KD. It's nice to see you. When is the I-485 transferred to field office on the day approved or the approval notice issued? So, it's usually, once you've applied and you've been approved for VAWA, that's what the C31 code is. Then you will VAWA, if you've applied for the I-485, then it will be transferred over to the field center. What the timing looks like is going to depend on a number of variables. It's going to depend on processing times, which service center is going to take your case. So you could be looking at another 6 months to a year. Hi, is it possible to buy your citizenship in the USA? Kind of. If you are going to do an investor's green card where you can invest in a business for a minimum of $900,000, you first get your green card, not citizenship. But then once you get your green card, you will get a shot at applying for permanent residence after 5 years. How long after first visit to the U.S. must long-distance U.S. AU couple wait before getting married? So that's really a very specific question. There's no set time. The law doesn't say that you have to wait for a certain period of time to get married. But of course, it's always advisable before you take any actions that you consult with an attorney to make sure that you're taking all the right steps in your process. So that's where it's important to schedule that consultation. I came to Trinidad a few years ago, being a permanent resident. I did not go back within the time. Oh, Katie, let's see. I was pregnant and wanted to have the child in Trinidad. Okay, so whether you have options is going to come down to the facts in your case. I did my removal of conditions through marriage last August. I haven't heard anything from them. So that's not strange, Chrissy. Just make sure that you've gotten your receipt notice, and you can always check your case status. But it's not out of the ordinary to not hear anything right away. Some people's cases are going for years. Some people's cases are going for a minimum of 2 years now. Great questions. Keep those questions coming. And thanks for the share. I appreciate it. What if I don't have any of those things you listed off to be a citizen of the USA? How do I help myself? So now if you don't have any of those things, then you can't be a citizen. I don't know where you saw that list, but if you saw a list here, first of all, make sure you get legal advice, right? Because I'm not providing personalized legal advice here. And so if you have received, if you see a list, you want to first get that specific personalized legal advice to make sure you really don't meet those requirements. But if you truly don't meet any of the requirements of citizenship to apply for citizenship, then you couldn't apply for citizenship. So it really comes down to facts, and you're going to have to do that consult. Now, if you'd like to schedule a consultation, go straight to the link in the profile. Everything is there you need to get set up. You have the link to the website, and you can schedule your own appointment. I got my green card 7 months, but it's been 2 years. I haven't heard anything about my children's application. So it's hard to say why, and that's where it's important to have that representation and legal advice. At the point that you've applied, it's very hard to say why you haven't heard anything about the children. If I am a U.S. citizen, can I adopt a child outside of the country? Yes. Now, how that's going to go, it's going to come down to the child. It's going to come down to the country and the laws regarding the specific country. So you'd have to get legal advice. How long did it take for the green card? Was your interview waived? Okay, so somebody's asking. What are the guidelines of prosecutorial discretion approvals? So it really is based on the discretion of the officer. You do have to, it's on a case-by-case basis. And so, you have an attorney. The attorney can present those, what the circumstances you may have. How long have you been here? How, do you have a criminal record or not? What is the seriousness of your violations? Why are you in immigration court, or why are you subject to deportation? If you would like to go ahead and you're interested in pursuing that, go ahead, schedule that consultation. Once I receive my deficiency notice for a medical form, how long does it take to get the interview? So it still differs. There's no set timeline that you're going to get the interview. Anthony, you're welcome. Peter Sunflower, thanks for sharing. You mentioned that they will process I-130, then send it to VC. Do they do that so the I-485 can be applied? So you're getting too specific and it's getting complicated. I don't know what your process is. I don't know what your case is. So you need to get personalized legal advice. I applied for adjustment of status. Let's see. I applied for adjustment of status. I adjusted my medical. How long will it be valid for? 2 years. How soon can we see you for our cases? So, Anthony, you can go ahead and call. It's really dependent on my availability. However, what the scheduling coordinator can assist you to schedule an appointment as soon as possible. You can go to the link in the profile. You can schedule your own, or you can give us a call. Thanks for the love. I complete the application on NVC for my kids. How long does it take for them to review the documents? So I'm seeing a few months, so 2 to 3 months to get an answer back from them. Can my husband being deported affect me from getting my visa? It may, depends on what happened with the deportation, but it may, depends why did he get deported? Was there a criminal conviction involved, especially if it involved drug trafficking? So it may. Good day. What's the waiting time when a citizen filed for her unmarried child over 21? So expect about 5 to 7 years. Can I stay with my U.S. born baby in the USA? It depends, Kaylina, on what's going on in your case. I don't want to tell you you can't, you may, but if you have no way to stay, you don't have a relative, you don't have employment, you don't have any humanitarian relief, then you may have limited options. But that's where it's very important to schedule that consultation, because I am able to hone into your facts and circumstances to determine what the best options could be. How long does it take for the NVC to review documents for the kids? So I'd say 2 to 3 months. Good afternoon. How long does it take to get back your green card after you do your renewal? It was a 10-year. So I have seen anywhere from 9 months to over a year. So it varies. All right, that's going to be it for me today. I was both on YouTube and I was on TikTok today. I'll be back tomorrow at around 4 p.m. So look out for me and you can come with your questions. I'll come with my topic. This whole week, I'm talking about how to apply for your own green card without a U.S. citizen or legal permanent resident spouse, parent, or son or daughter who may be mistreating you. And I'm talking about the different ways. Now, stepchildren, did you know stepchildren and step-parents could qualify for this relief as well? I'll talk about that tomorrow. And on YouTube, go ahead, like and subscribe so we can continue sharing this very good information with intending immigrants, with immigrants who are already here, and you need that information. But keep in mind, even though I'm a U.S. immigration attorney, I do represent clients in all 50 states and the globe. I am not providing you personalized legal advice. This is general information that is there to empower you and educate you, but I'm leaving it up to you to get the consultation you need to move forward and take action and empower yourself. So I'm also available for that. Go to the link in the profile on TikTok and on YouTube on the About. You'll see the link to the website. All the options are there to get in touch. Have a great